But one of the things that's kind of, well, not kind of, it is staggering about the nature of the internet is that, of course, it is worldwide. So I advertise here, post everything on the server that I purchase space on. Maybe it's in Los Angeles, okay? And then who sees my webpage if they were to look for it? Anybody. A client in Bangladesh, or a person who is interested in the information I have to provide. A person in South Africa, someone in Belarus, anybody. Aliens. If you've watched Transformers, you see how that works. So we don't get confined in our advertising to our own jurisdiction. There are no longer any boundaries about the jurisdiction. Okay. The sun is coming out, so we're getting even brighter. Sorry about that. That doesn't mean we can't use the internet. We have to be mindful of jurisdictional boundaries. I'm not licensed in another state in this country, never mind other countries. So I can't practice in other states. I can only practice in California. We should be clear what our jurisdictions are, where we practice. So if we get a contact from somebody who lives even close by in Nevada, for example, or Oregon, and say, you know, you're the one person, Dr. Petty, who you kind of your combination of information, you're the person I want to work with. You will then be able to say, well, you live where? Well, I live in Oregon. I'd love to just do phone therapy with you. You know, I'm sorry, but I can't practice outside of my jurisdiction. Okay? So the reasons for that, and by the way, lots of folks, I think, are now practicing outside of their jurisdiction because there's a lot of cross-jurisdiction, you know, kind of information, and clients and people who are potential clients are not seeing this as a barrier, which in some ways you could argue that's exactly why you have the internet. It's like there aren't any barriers to getting information, right? And so it doesn't mean that it's either safe or a good idea, and there are some really significant legal issues about practicing outside of one's own jurisdiction. Just as a couple of examples, one of them is, as most of you know, our immunity from liability if we make a child abuse report in California is among the strongest immunities that anyone has in any state, and it's quasi-judicial. We get sued, it gets dropped 99.999% of the time if we've made a report and someone sues us for reporting. Okay? So we have a very, very strong section, it's 11172 of the Penal Code. And other states, for example, Colorado, only have a good faith protection, which means that if I'm seeing a client in Colorado, she lives in Denver, well, where the person resides typically is the place the service is assumed to occur. So if I live here and I'm on my cell or I'm Skyping, don't use Skype, but if I'm Skyping, nothing against them, wonderful for friends and family, but for professional purposes, privacy is an issue. They do track information. Still, if I'm Skyping with someone or using some other method, where they live usually governs where it's considered to be that's the jurisdiction in which the services are being provided, where they reside. Okay, so I'm talking to somebody in Colorado. Colorado doesn't have an ironclad immunity like we do. They have a good faith immunity. So I would have to go into court and prove that I made a report about that client or about a third party in good faith. I'd have to know the Colorado standards were different than ours. And there's a whole lot of law to know about one state to the next. So that's one of the practical reasons to be concerned about advertising and then practicing outside of one's jurisdiction. It's a little different when you talk about a client who goes on a vacation for a couple of weeks, because if they still reside in San Francisco, they haven't changed their residence. They've changed their location. So one could make a good argument that you have it now, you're not practicing in the other state. But I have to tell you that, to my knowledge, those cases have not been clarified by courts. We do know that boards do go after professionals who practice in their jurisdiction and who are not licensed. The Hegeseth case is one example. Began in 2005. It kind of culminated in 2009. It involved a psychiatrist in Denver who apparently had a website where he did screening online of people for various types of medications and said he would prescribe. A freshman at Stanford was apparently feeling very distressed and depressed and contacted Dr. Hegeseth. Did the evaluation over the internet, may have talked to him on the phone. I'm not sure if he did in person, but it's possible that that happened. And the physician prescribed psychotropic medication for the depression. I think within about 6 months, this young man killed himself. As one of the many horrible consequences, the DA in the county decided to criminally prosecute Hegeseth for practicing medicine without a license in California. Hegeseth was convicted and was to spend 9 months in jail as a result. He did his jail time in Colorado via a cooperative agreement, I guess. That's an extreme case, but it's an example of if you have sufficient contacts in a state and you do things that are considered practice, you are then practicing in that state. I'm not sure what Hegeseth argued in court to counter the idea that he was practicing in California. It seems like it was a pretty hard argument to make that he was not practicing here. There's an idea in jurisdictional law, in law related to conflict of laws as well as whether you're in one jurisdiction or another, that has to do with whether you have sufficient contacts in a particular state. Well, one of the arguments that the DA made was that by advertising on the internet, he had sufficient contacts. Right? And then if you go a step further and you're actually talking to people and providing the service, you can see how that would be a pretty significant series of steps and could end up in difficulty. Does that make sense?
Yeah, what about internet? Yeah.
So international, or the use of Skype, it has to do with the other jurisdictions. So if one of the other jurisdictions, let's say, is Rarotonga, okay? Rarotonga is in the Cook Islands in the South Pacific. Why anybody would need a therapist there, I don't know. But let's say that one Skypes or does some other video method with that person. If there are no laws prohibiting our practice there, then we wouldn't get in trouble. But you'd have to know what the laws of those jurisdictions were. Some countries don't have any regulations or laws that, that address licensure and standards of practice for mental health professionals. And so many countries don't have child abuse reporting laws. So you would have to know what you were getting into. It's tricky. And in terms of Skype, and this is just a throwaway, Skype at least just says they track traffic. That doesn't mean that they're actually keeping all of the video, although theoretically they could. Doesn't mean they're doing that. It may mean that whatever backdoor the NSA has, they're keeping all the video. But what it means is that they get to know who calls whom, when, how long, all of that. There's traffic information. And so that can be put together to create some inferences about various behavior that can be pretty sophisticated. So there are some sites that you pay for. Here's again the whole idea. Skype is free, or at least initially free. If you pay for some of the sites that allow you to do video chat through those sites, and they may guarantee higher levels of privacy, and they will explicitly say, we do not track traffic. So if folks are going to do that professionally, and this can include, if you're going to be consulting in a different state and you get permission to do that, or the state allows, like California does, 30 days of practice in a calendar year for a person with a valid license in another state. That means 30 days, like once every few weeks or something, or once every couple weeks. That I'd want to have a secure method of engaging in those interactions, at least to the degree that's possible for us as lowly citizens.